LiberalViewer presents.
So, welcome to LiberalViewer First Wednesday live Q&A. This is the live show I do on the first Wednesday of every month to answer viewer questions that accumulate during the month, and I'll answer some questions from my live viewers along the way or at the end as well. And as I've been requested, I'm going to mainly focus on recent Supreme Court decisions, though there are a couple other topics you can see down in the video description. But first, I want to make up for a technical problem I had on my broadcast last Sunday, in which I hope to show clips of Bill Maher and Judd Apatow discussing Bill Cosby and the rape allegations against him, and especially the difference between how you treat those kind of allegations in a court of public opinion and a court of law. Since I was a criminal defense attorney for about 5 years, I guess I do kind of approach things tending toward a presumption of innocence, but eventually there can be enough out-of-court evidence to allow the court of public opinion to draw some conclusions, as you can see in the first clip of Bill Maher and Judd Apatow last Friday that I'd hoped to show last Sunday over here.
All right, so Bill Cosby. Let's talk about Bill Cosby, because I've talked about him before. I think I was one of the first ones to make jokes. I never felt bad about it because I was not divided like many comics were, who always were fans. I never thought he was funny. I've said that before. So it wasn't like, oh gosh, he's such a great artist, but he turns out to be this rapist. First of all, what is your answer to people who say, well, he deserves his day in court?
Well, I think he's very lucky that the statute of limitations is like 6 years in most states. In California it is. So I think he's
or that they're just allegations.
Well, yes, you can say that, but you know, he's free. I mean, the country hasn't thrown him in jail. So, but if he's free, we're allowed to say when 40 people accuse you of something, there's a pretty good chance that it happened.
That's the difference. People have to understand size matters.
Yeah.
No, seriously. It does. I mean, you hear, yes, I'm very, very wary. I never used to do Michael Jackson has sex with little boy jokes.
Yes.
Because I don't know if that's true. I mean, over the years, it became a little more apparent it might be. But, you know, you hear, oh, Tom Cruise is gay. I've seen people make that joke on shows. I don't think I don't know. Nobody knows. But I don't think he is. Who cares? It's just, but that's a real, just out of my ass allegation. But 40 women, many with no reason to be doing this. There's no money that's coming to them. They're not looking for fame because some of them already have it.
Well, it's not fun to go on CNN at 65 or 7 years old and say that Bill Cosby raped you in the 70s. I mean, there's no reason to do it. And people have to remember that 80% of rape victims never report it to the police. And 80% of rape victims are raped by somebody they know.
So you got into this just because you're outraged?
Well, I'm outraged by I actually know one of the victims who's not coming forward. And she said, this is exactly what happened. And I think there's probably a lot of people who are like, I don't want to go on TV. I don't want to make this what I'm about as a person.
I met a girl, I did a movie with someone in 1983 who had just come off a movie with Bill Cosby and had a horrific story. It's like, I never meet anybody of the female persuasion who doesn't have a story about Bill Cosby. This guy has put more people to sleep than warm milk.
So that was like the joke that I couldn't show last Sunday, and I do think that when the evidence builds up, you can start to put the burden on the accused in the court of public opinion to an extent that you don't do in a court of law, where there's a presumption of innocence and and you have to be proved guilty beyond a reasonable doubt for these crimes. Although the presumption of innocence and having to be proved guilty beyond a reasonable doubt, those phrases don't occur in the Constitution or the Bill of Rights, which I will get to later when I talk about substantive due process and some of the Supreme Court cases. But before I get to that, I want to show one more clip from HBO's Real Time with Bill Maher last Friday. This starts with Michael Eric Dyson making a comparison between Bill Cosby and Woody Allen, which I think is problematic, and Bill Maher points that out and puts Bill Cosby and then Roman Polanski on one side and Woody Allen on another, just based on the amount of evidence. And I'll talk about it a little more and then get to the Supreme Court cases after you see that clip over here.
that if we're going to find offense with what he said, there's so much arena there, so much area, so much real estate to talk about a bunch of stuff, including that. But Woody Allen have to be thrown in there, and Roman Polanski as well.
No.
You don't think so?
See, this is just what I said. It's not 40 people, it's one.
Well,
What?
I can't.
Woody Allen, it's one accuser who had every reason to hate him.
You mean?
Yeah, I think.
Ronan? Right. But Ronan Farrow as well.
Polanski, definitely. That's right. I agree. I have no quarter for Roman Polanski or Ted Kennedy. You know, there's certain things you can't do. Can't drive into a river and not report it for 10 hours when someone drowns. And you can't have sex with a girl in the naughty place after you drugged her.
Amen. Amen.
But come on, I mean, that's the difference we're talking about.
You're exactly right that when these allegations come forward, it is tough to do this balancing act with due process and in the media and talking about the allegations. I think you're exactly right, and we have to do that. The 40 women at this point gets to the point that we think this is true, right? I do think the outrage question about why there's not much outrage, there was for a short time. As I write in my book, Into Discussion, the outrage cycle is very, that's right. The outrage cycle is super short. And a lot of times something that we truly should be outraged about is foisted off of the news cycle because of something that we really shouldn't.
But I think a lot of it,
powerful too.
I think a lot about it is like how funny they are. You know, people don't want to believe it about Woody Allen because then you can't enjoy Woody Allen movies, so they instantly don't believe his daughter. You know, people think Bill Cosby is so funny that it takes 40 accusations before we begin to think it's possible. I mean, if this was me, I'd be screwed at 2 allegations. You're like at a 17 to 19 allegations.
That's pretty generous. That's generous.
Judd, your last...
Now, that's kind of a funny comment from Judd Apatow, and I'm a huge Judd Apatow fan, going back to Freaks and Geeks, which is one of my favorite TV series ever, and I have like the special edition with the yearbook from not the Vikings. What was the name of their... anyway, I can't remember the name of the mascot in Freaks and Geeks, but that's the name on their yearbook. And anyway, but on the topic of what they were talking about, I actually have, I think, been a little too much... looking at things. I've looked too much at some of these things from a legal perspective in terms of people being presumed innocent, and that testimony against them has to be subject to confrontation, and in a court of law where they have a chance to confront their accusers. That's one of the rights in the Bill of Rights that's actually mentioned, and to confront the evidence against you. That's sort of a basic right of due process. And those are really important rights, but in the court of public opinion for something like this Cosby case, where there are so many women who have the same story, eventually you don't have to have the presumption of innocence, and you don't have to prove people guilty beyond a reasonable doubt for them to start, for their reputation to start being questioned. That's different from criminal punishment. For criminal punishment, you need all those due process protections. But, you're not going to necessarily have like a presumption of innocence and have to prove people guilty beyond a reasonable doubt before you decide like who you're going to leave your children with as a babysitter or whatever, or those kinds of things. Those, that's not a court of law, or that's the court of public opinion, or just like your own personal risk assessment doesn't necessarily have to meet that standard, which is required by due process in the Bill of Rights, even though it never actually mentions that. And that gets me over to the Supreme Court opinions I want to discuss. Well, the first one I want to discuss will come after the first question I had asked quite a long time ago. It's kind of interesting. This was back at the end of May. I had a question posted by Terry Alther for my July show. This was even before my June show. Here's the question. You can see. I don't know how well you can read that, but he says, first question for July. I was looking at all the Memorial Day posts when I stumbled on this article, and it talks about how every Confederate veteran is by default an American traitor. What do you think of honoring Confederate veterans on Memorial Day? And you can see those Confederate flags being put up on Memorial Day. And I actually even asked him, you can see down at the bottom, if he still wanted me to cover this after the Confederate flag broke as such a big issue on, what was it, June 17th, when that shooting was in Charleston, South Carolina, and now the Confederate flags are coming down all over the country. It's actually kind of a big coincidence that Terry Alther asked that question. There's been a lot of coverage of the Confederate flag about how, and I covered this on my Sunday show week before last, about how the flag that we are calling the Confederate flag is really the Confederate battle flag. It's not the flag of the Confederacy, which is like a red stripe, a blue stripe, and a white stripe with like a circle of stars. It's not the one you see like the Confederate flag that was in that picture I just showed. That's the Confederate battle flag. It was the battle flag of the Northern Army of Virginia, and that was never in any of the Southern state flags. Like, wasn't flying over the State House in South Carolina until like the 1950s as a reaction to desegregation, and so it really is a symbol of racism. And it's you know, Terry Alther, in his when he replied to my question about whether I should still cover this, you can see down there, if I don't know how well you can read that, but when I, sorry, I'm having a little, oh, there it is. He said it would be a good wrap to talk about it, especially since this has been an issue for so long. I think one final blow should settle this in stone once and for all. And he talked about how, or what he's talking about is how we can get rid of the flag. Oh, sorry, I need to do a little Marco Rubio here, although I have the question up so you can't see me. Yeah, I need to take a little drink of water, sorry. So, yeah, I think that the Confederate battle flag has been more recognized as a symbol of white supremacy since this shooting back, I think it was June 17th, June 18th, I think June 17th is the date of the shooting at the AME Church in Charleston, South Carolina. But one of the interesting things that also came out this last week was a Supreme Court case that dealt with the Confederate flag. It was about whether Texas had to allow a Confederate flag to be put on the license plate. And I actually think, even though the Supreme Court decided against the Confederate flag, that they decided this case incorrectly, as I will explain. I put a link down in the video description. You can read the whole case yourself. I think the name of the case is, let me make sure, it's Walker versus Sons of Confederate Veterans. And it talks about whether Texas needs it. Basically, Texas opens up its license plate if you get enough signatures on a petition for your group to get a special license plate. It's not like your own personalized license plate. It's a group effort. And if you get like 250 signatures or 500 or whatever, you can get like Sons of Confederate Veterans or pro-choice for Texas or pro-life for Texas or whatever in a little square on the license plate. And the Sons of Confederate Veterans wanted to get that on the license plate with the flag, and Texas turned them down. There was actually another case in another state, I can't remember which state, where there was a pro-choice group trying to get their message through one of these like group specialty license plate deals. And what the Supreme Court said is that it's actually government speech that's on the license plate. Which I think is kind of wrong. I think if they open up a little square of the license plate, and this was actually the ACLU position on that pro-choice plate, if the government opens up a little square for public speech, then they have to let any group say whatever they want. It could be, you know, I'm pro-choice, I'm pro-life, I'm pro-Confederate flag, but that's not what the Supreme Court decided. You can read the case down in the video at a link in the video description. What they decided is it's government speech. And so the government gets to decide what goes in that little square on the license plate. And that could also mean now that on the upside, even though I think it was more of a public forum and it should have been a free speech area, on the upside from that decision, it means that now we can bring cases to say that things the government shouldn't be saying, like get rid of all the Confederate flags on all the license plates all over the country, because that's government speech that is offensive. It's not free speech of individuals. So anyway, I wanted to talk about that for a minute. Now I want to go to the next question I had. Oh, and I need another little Marco Rubio. Where did I put that one? Oh, here it is. Here's the next question I got. This is from Ed Gloss. He said, I have a question regarding the Friday's decision. I back same-sex marriage completely, and I'm a non-believer, so hopefully that'll help in some way to demonstrate that my question is genuine. Given that same-sex couples have been granted equal protection under the law, what would happen if a bed and breakfast, particularly an intimate one, owned and operated by a couple who personally cooks meals, make up the rooms, like a bed and breakfast, they deny service to a gay couple on the grounds that it goes against their religion? Do they have a case? I'm torn here. I think I lean in the direction of them having the right to be bigots. Well, first of all, I talked about equal protection last Sunday when I talked extensively about the Obergefell versus Hodges Supreme Court decision that gave marriage equality to couples in all 50 states. But actually, equal protection was not the ground of that decision. And I put a link down to the Obergefell versus Hodges decision in the video description. They didn't decide the case based on the Equal Protection Clause because that would have required them to decide the level of scrutiny that they would give to claims by gay couples of discrimination under equal protection. See, the deal is the 14th Amendment says that no state can deny any person equal protection of the law. But for most laws, if they treat different groups of people differently, like if they treat, people who live near the river different than people who live, far from the river and how they, can use water or whatever, that's not what's called a suspect classification. And so that just has to be based on what's called a rational basis. It means it has to rationally further a legitimate government purpose, which is the lowest level of scrutiny. If you are discriminating against a suspect classification like race or ethnicity or national origin or religion, then you have to show then the court gives the highest level of scrutiny to the law, and it has to be narrowly tailored to meet a compelling state interest. And the government almost never wins when they get strict scrutiny on, or that highest level of scrutiny on the law. But the thing is, that's not how this case on marriage equality, gay marriage, same-sex marriage rights was decided. It wasn't decided on the basis of equal protection. It was decided on the basis of what's called substantive due process. And I actually had a question about that posted in the comment section. Here it is. From Fox Fact 1, my friend is a harsh critic of substantive due process. For this reason, he denies the right to marriage and disagrees with the majority in Obergefell versus Hodges. What is your take on substantive due process? And then there's a follow-up question I'll get to in a minute. But basically, substantive due process doesn't come from the Equal Protection Clause. It comes from the clause of both the 14th Amendment and the 5th Amendment. In the 5th Amendment, it says that no person shall be denied life, liberty, or property without due process of law, and that applies to the federal government. And then in the 14th Amendment it says no state shall deny any person life, liberty, or property without due process of law. So that's the due process clause of both the 5th and the 14th Amendment. And since it says liberty in there, no state or the federal government can't deny you liberty, that means the government can't deny you a fundamental right to liberty, any kind of fundamental right to liberty, without the government having to undergo that same strict scrutiny I was talking about for the suspect classifications, meaning it has to be narrowly tailored to further a compelling state interest. And fundamental rights are, almost all of the rights mentioned in the Bill of Rights are fundamental rights. Not all of them. I think the right to be indicted by a grand jury has not been found to be a fundamental right. I think the Third Amendment right not to quarter soldiers has never come up as a fundamental right. But almost all the other rights in the Bill of Rights are fundamental rights. But in the Ninth Amendment, it specifically says that you don't have to name all the rights. The rights named in the Bill of Rights aren't all the fundamental rights. There are other fundamental rights, and other fundamental rights have been found, like the right to vote isn't mentioned in there, and it's a fundamental right. The right to freedom of travel isn't mentioned in there, it's a fundamental right. And of course, a big one that conservatives sometimes hate is the right to privacy. And the right to privacy includes the right to make intimate decisions about family and marriage and reproduction. That's like the heart, the core of what the courts have found to be the right to privacy. That's why it protects like the right to decide whether to have an abortion. That's under the right to privacy. And the right to get married. The right to decide who you want to marry. And that is not a made-up right that just came about in this latest decision. That goes back, I think I showed a clip last Sunday of Ted Olson saying that it had been cited by the Supreme Court 14 times, the fundamental right to decide who you want to marry. That's a liberty that's protected by the Due Process Clause of the 5th and the 14th Amendment, because the state can't take away your liberty without due process of law. And if it's a fundamental right, that means that what they do, whatever the law is, has to be narrowly tailored to further a compelling state interest. And there is no compelling state interest in denying same-sex couples the fundamental right to choose who they want to marry. That's the same fundamental right that was upheld in Loving versus Virginia, which was upheld by a 9-0 vote by the Supreme Court, citing the fundamental right to marry. I'm kind of sad that this latest case, Obergefell versus Hodges, was a 5-4 decision. It really should have been 9-0, the way I see it, based on the precedent. But anyway, I think that talks about the substantive due process, but I haven't really answered the question from Ed Gloss about the person who has a bed and breakfast here. I just wanted to point out that the Equal Protection Clause is not the reason that you have a right not to be discriminated against in housing. In fact, the non-discrimination laws, those are specific laws that apply federally for like race and ethnicity and national origin, but there is no federal law that says you can't be discriminated against in housing and employment based on your sexual orientation, unfortunately. There's been one proposed called the Employment Non-Discrimination Act, ENDA, but it hasn't passed. A lot of different localities have that law, and it depends on the text of that. But the federal non-discrimination housing law actually has what's sometimes called the bed and breakfast exception. And I wanted to show the text of that law. I put a link down to the law in the video description. What is it, 42 USC, was it 3603? I can't remember. Anyway, rooms or units and dwellings containing living quarters. This is an exception to the non-discrimination law. Rooms or units and dwellings containing living quarters occupied or intended to be occupied by no more than 4 families living independently of each other, if the owner actually maintains and occupies one of such living quarters as his residence. So actually, you can discriminate against people in housing that you live in and holds 4 separate families or less. So that is sometimes called the bed and breakfast exception to the federal non-discrimination law. So I think that answers that question from Ed Gloss. Although, like I said, it depends on what the local non-discrimination law would be, and they may not have that same exception. But usually there is that kind of exception, but it depends on the locality. Now, getting to the next question I had asked before I started the show. Oh, sorry, that's not it. Here it is. It's from Cruz 2. He questioned for LiberalViewer Q&A Wednesday. If Bernie Sanders wins the Democratic primary, please explain the regulations he would have to face if he decided to publicly finance his election. Would it be better if he just continued collecting donations through his campaign? Sorry, I need another quick little Marco Rubio there. And basically, the public financing system, the upside is that you get a huge amount of money from the federal government to fund your campaign, and then you have to stick to these spending limits, which increase every year. Here, I put a link down in the video description to a brochure from the Federal Election Commission that describes the presidential matching fund. And I think, is this it? Yeah, this is a link to the most important part is the footnotes, because the amount increases every year, and so the cost of living adjustment for the national spending limit that you had to agree to is $45.6 million if you accept the federal matching or the federal public financing for your presidential campaign, and what you get for that is $91.2 million. And the thing is that most candidates in the last election cycle, both candidates in the general election said, forget it, I don't want the money, I just want to be able to spend as much as I want, because they were able to raise so much money over the internet, especially Barack Obama. He raised so much money over the internet that it was better for him not to take the $91 million because he didn't have to follow the national spending limit. And I think that's going to be true for the foreseeable future until they raise up the amounts of public financing so they're more competitive. And I'm actually a big believer in those federal public financing systems. I think if there were more public financing, both of presidential campaigns and congressional campaigns, especially big matching programs for small donations where you agree to take like $100 contributions, and then they're like triple matched with, for every $100 contribution you get a $300 from the federal government, something like that, where it builds on support from small donors. I definitely would be in favor of something like that. And anyway, I think if you look at that brochure that I posted down in the video description, you'll see what those federal campaign limits are. I have one more question you saw before. It was like a two-part question that was posted down in the comment section before I started the show from Fox Fact 1. He first asked about substantive due process, and I think I talked about that pretty extensively. And then the second part was, can you explain Thomas's argument in regards to the courts creating a right to dignity in his dissenting opinion? I didn't read all of Thomas's dissenting opinion, although I did read that part, so I have to, full disclosure, point that out. But in his part where he's talking about dignity, I mean, I guess I understand his argument. His argument is that dignity, it's basically your rights are inalienable, and they're, they come from God or from endowed by our Creator by certain inalienable rights, which means the government can't take them away. So if you have dignity and that's something that's imbued by your Creator, the government can't take away your dignity, even if they enslave you or deny you the right to marriage equality or whatever. And that's what Thomas actually said in his opinion, that even if the government enslaved you, they didn't take away your dignity, because the government can't take away your dignity. It's something that's endowed by your Creator. So that was his big answer to Kennedy's majority opinion that talked about how you have a right to be treated with respect and dignity by your government. That's basically the basis of what due process is. That's something that I've talked about over and over again in my videos. It's something I believe very strongly. In a way, it's a value it's one of the positive values you can find in most religions, that every person has a right to be treated with respect and dignity. That doesn't mean that you have to get it from religion. You can find it in most the philosophies that I like anyway. That's something you can find from Immanuel Kant, or that's the basis of natural rights theory from John Locke, which got put into our Constitution, and that's basically why we have a due process clause from John Locke. I think it went through some other philosopher before it got into our Constitution, but it basically, John Locke said you have the right to life, liberty, and property, and that became the government can't take your life, liberty, or property without due process of law. So I'm a strong believer in natural rights theory, and that you are endowed by your Creator with certain inalienable rights, Creator, whatever that's supposed to mean. But that doesn't mean that when the government enslaves you or denies you benefits, that denies you certain fundamental rights, like to decide who you want to marry, that they're not hurting your right to respect and dignity. That's why the court is there to enforce those rights. And anyway, I understand what Thomas is trying to say, but I just don't buy it as an argument. So I hope that answers both the questions from Fox Fact 1, and I think I've been going for almost 30 minutes now, but I noticed that I've picked up almost 40 viewers at this point, so I want to scroll through the comment section real quick and see. Let me take a little drink of water here again. Start back at the bottom. I see. See, every time someone posts it, it's very hard to do this live because every time someone posts a comment, it like moves the thing I'm trying to read. But I saw, let's see, I was reading it earlier, and NO8549 says, how long can the anti-gay marriage court clerks continue to deny marriage licenses on the basis of their right to religious freedom? Well, I mean, the farthest I can see that kind of claim go is, I mean, I suppose a government agency could provide some alternative person to do that job, maybe. But basically, if you can't do the job, if you can't, provide equal services to all the people, I don't see that as a defense against providing marriage licenses to same-sex couples. I don't think that's going to work as a defense, and I think that's pretty much not even being tried. Most places, I think marriage equality has pretty much come to all 50 states. I mean, I think there are some holdouts in a couple states that are trying this religious freedom deal, but I don't think it's really going to get very far. Although there is this whole Religious Freedom Restoration Act stuff that, that was back last spring was a big issue in Indiana, when Indiana was going to pass this religious exception that allowed people to discriminate against LGBT people, based on their religious convictions. And I saw this, I mentioned this briefly in my live show on Sunday, that the deputy legal director of the ACLU, I think that's her title, Louise Melling, posted this editorial in the Washington Post about why the ACLU is now actually, even though the ACLU once supported the Federal Religious Freedom Restoration Act, the federal RFRA law, they are now opposing it or trying to amend it so that it can't be used as a basis to discriminate against other people, based on their immutable characteristics like race, ethnicity, or sexual orientation, or gender, or whatever. That it was never meant to do that. The Religious Freedom Restoration Act was passed by a coalition, including the ACLU, after this Supreme Court case in the late 1980s, Employment Division versus Smith, about these Native Americans who were fired from their jobs and then couldn't get unemployment benefits because they used peyote. And they were fired for using peyote, and it was in a religious ceremony, and they were denied federal unemployment benefits. That's why it was Unemployment Division versus Smith. And the Supreme Court said that a law of general applicability that's not like focused on your religious practice, if it just happens to burden your religious practice, then you have to obey that law like everyone else. And that actually does deny some religious freedom to individuals like those Native Americans who wanted to use peyote. And there should be some exception for individuals who are trying to exercise their religion in a way that doesn't impact on other people. It's just, their own religious expression. But that's different from giving employers and institutions a right to, it's using it as a shield against the government punishing you versus for your individual religious expression, versus using it as a sword to hurt other people, your employees, or for institutions to set policies that discriminate against people. And that's why the ACLU has now come out for amending the Federal Religious Freedom Restoration Act, and I guess will be opposing some states who are trying to carve out these religious exemptions so that people can discriminate against LGBT or other kinds of. I mean, I think the big rule of thumb on this, not to use the word. For those who know where rule of thumb comes from, I apologize for that reference. But the rule should be that if now I lost my train of thought with that reference to the rule of thumb, which was about I think the rule of thumb means that you can like beat your wife with anything that's no thicker than your thumb. But I mean, basically, I just think that if you're using it to discriminate against someone, like the ACLU position is saying, that if you're using it as a sword, if you're using it to, okay, now I remember my train of thought. Sorry about that. The rule I was thinking of is if you can put racial discrimination in the place of LGBT discrimination and you're not horrified, then it's okay. So. I mean, if in the people who want to deny the bed and breakfast, or the people who want to not bake a cake or not cater the wedding, would that be okay if it were an interracial couple, or if they didn't want to do it for African Americans? If the answer to that is not that would be okay too, then it shouldn't be okay for marriage equality, same-sex couples either. I don't understand why, on the one hand, it's okay, but for racial discrimination is horrifying, but anti-gay discrimination is okay. I don't quite get that. Let me see if I can find one or two more questions that were posted live here from a couple other people. Let's see. I think the problem, and you're like talking to each other, so it's very difficult for me to. One other thing I wanted to talk about that I put down in the video description was the death penalty decision. I don't think I really talked about that very much on my Sunday show, and it hasn't got a lot of coverage because of the other big decisions. It was a really bad decision written by Justice Samuel Alito, where basically it's about this drug cocktail they use to put people to death by lethal injection in the United States. And what they do is the first drug is supposed to put them to sleep, the second drug is supposed to paralyze them, and then the third drug actually kills them. And the problem is the third drug is really, really painful. That no one seems to disagree about that. It's like, I think some of the testimony was it's like being burned alive. And the second drug paralyzes the people, so they may or may not even be able to show that they're being subjected to torture, basically. And the first drug that's supposed to put them to sleep, well, the drug they used to use, no one can get it anymore because the European countries who manufactured it have been subjected to political pressure no longer to give it to the United States, where it's being used to kill people. And so they've been like trying these new drugs, and there have been these botched executions, and it's been really like Oklahoma, where this case came from, and it's really nasty. And what's really nasty about Samuel Alito's opinion is that he says basically it's up to the person being executed to propose some method of execution that would be less painful than what the state is using. And I don't know where that comes from. I mean, I talked about substantive due process. You have a right not to be deprived of life, liberty, or property without due process of law, and life is one of those fundamental rights. And I don't see why the burden is suddenly on the person being executed to come up with some less painful method if there's all this huge amount of evidence that what they're doing is basically torturing people to death over a course of, sometimes even hours. Some of these botched executions are, it's just horrible if you read the details. I don't want to go into that. So I wanted to make sure I covered that. I put a link down to the death penalty case in the video description if you want to read that yourself. I want to see if I can find someone said Malkadon says you lose all dignity at the DMV. So that was, I guess, that's a different kind of dignity. But, one of the things I wanted to say about the right to life, liberty, and property is I think those are in decreasing order of importance. They're all important, but the amount that the government has to, or the amount of due process that you get before the government can take it away is less for liberty than life and property than liberty. In fact, I think by a majority vote, people can raise taxes and take away pretty much any of your property, although one of the bad cases that came out on the last day of the Supreme Court that I haven't talked about is this case about the EPA regulating coal emissions, and the Supreme Court basically said that regulation had to involve the amount of cost of the regulation, and it got rid of the EPA's ability to regulate coal. But anyway, I don't think it's that big a deal. Anyway, I wanted to thank all of you who joined me. I apologize to my live viewers here that I wasn't able to do a better job of reading through your questions. The stupid little scroll I get is every time someone posts a new comment, it like bounces up to the top, and so it's really difficult for me to read as a live thing. I don't know. Maybe I should get some moderator to help me pick out questions. If this were popular enough, maybe I would. But anyway, if you want to support my live videos or any of my videos, I put up little cards in the corner here. If you click on the little eye that shows up there, you can give a direct donation through fan fundraising, or on Patreon you can become one of my patrons. I appreciate all the support I get to keep doing the live videos. YouTube recently demonetized like a third of my videos based on some weird software algorithm that looks for any word in the description or the title that might be offensive to anyone, and it's really messing with my monetization. So I really appreciate those who are helping me to switch over to a subscriber supported model of continuing to make these videos through 2016. Which is what I would like to do through the 2016 election, continue basically what I'm doing, although I may be making a video sometime in the next couple weeks about some changes on the channel. I may move my live videos over to a different channel. I'll be asking for comments about that through a video, and asking my patrons about that, what they think about having a live video channel and an edited and a channel just for my edited and produced videos. But anyway, until I start doing something different, I will keep putting my Sunday clip roundups will be on this channel at 6:30 p.m. Pacific time on Sunday. I will be making this week's show, and so I hope you'll join me for that. And I guess until I see you on Sunday, I will be seeing you all around the internet.